We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
I'm named for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings.
Welcome back, everyone. And thank you for joining me on this dramatic journey into yet another courtroom disaster. Today's case involves Marcus Campbell, a sovereign citizen attempting to use his creative legal tactics to fight off debts that, by all accounts, he clearly owes. What we're about to witness is a textbook example of how these strategies consistently fail. Under pressure, no matter how many times they're tried. From flawed arguments to missed opportunities, this case is a mess in every way possible, and we're going to break it down, step by step, and reveal the shocking twists that led to a resounding defeat. Buckle up.
For summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
So right from the start, we're already deep in the weeds with Marcus Campbell's legal strategy. He files a motion for summary disposition, but the court's response is straightforward. Are you even listening to what I'm saying? And let's be honest, this isn't the first time we've seen a sovereign citizen get tangled in legal jargon. They barely understand. The truth is, if you don't know the legal process inside and out, you're just wasting everyone's time. And from the looks of it, Campbell's strategy is about to implode, just like we've seen in countless cases before.
For summary disposition, that if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCarl, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022.
3-0. Campbell is trying every trick in the book, and it's just not working. There's talk of a brief in motions being filed, but none of it really seems to hold up. The filings are so confusing that even the opposing attorney, Mr. Mart, admits he doesn't understand the content. This is a classic sovereign citizen move. Throw enough paperwork at the court in the hope that something sticks. But when you dig deeper, all you find is a house of cards built on nonsense. And you know what happens to houses of cards, right? They come crashing.
The defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then he in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.70.
And here comes the court's response. No punches pulled. The judge calmly explains that there is no valid legal argument here, and that Campbell's filings are nothing but a string of confusing nonsense. This is where it gets interesting. The judge knows exactly what's going on. He's dealt with cases like this before, and he's not buying any of it. It's almost like watching a seasoned boxer avoid every punch thrown by an amateur, Campbell's. Moves are just too predictable, and yet, despite all the delays and deflections, the law is still the law, and it's not bending for Campbell.
And I'll stand on my brief.
And you stand on your pleadings. Okay.
Which was
All right, the court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there's no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today.
It's finally happening. Campbell admits he owes the money. This is where the whole sovereign citizen argument unravels. After all the back and forth, all the legal loopholes, Campbell comes clean and basically admits he owes the debt he was fighting so hard to avoid. It's almost like watching someone try to climb out of a hole only to dig themselves in deeper. This, right here, is why these tactics always fail, because eventually the truth comes out. And there's no amount of paperwork that can
Good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here.
we see the final push from the plaintiff's side. The motion for summary disposition is granted. This is it, the moment where the judge delivers the final blow. It's a decision that's been coming for a while now, and all of Campbell's attempts to delay and obstruct the process are officially deemed pointless. When you go up against a well-prepared legal team, your flimsy arguments won't hold up. This is why trying to manipulate the system with legal loopholes is a losing strategy every time. The facts speak for themselves, and Campbell's failed to offer any real.
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirschenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion, the summary disposition filed by the plaintiff. Mr. Kirschenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr.
Yes.
Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
Here is the missed opportunity. Campbell was given every chance to prove himself, to show the court he wasn't just a man spouting legal jargon without substance. He had a final chance to make his case on June 13th. But guess what? He didn't even show up. Not only does this leave the court with no defense to consider, but it solidifies the idea that Campbell never took this case seriously in the first place. What kind of legal strategy ignores the very foundation of what it means to be in court being present and engaged?
Motion. Is that what you're both telling me?
Yes, as long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22-198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with the genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell,
Yes.
your response, sir.
I sent a brief regarding the denial.
Yes, the
No.
court had the opportunity to read your brief. And I thought it was an interesting set of.
Another case of a sovereign citizen's legal dreams being dashed against the rock of reality. Despite all the bravado, the arguments, and the motions, Campbell ends up with a big fat 0 for. 3, the court has spoken, and the ruling is clear. The plaintiff wins, and Campbell loses. What does this teach us? It's simple. No matter how creative your arguments are, the law is not a game, and the court isn't here to entertain your conspiracy theories. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all right.
filed here. And I
Yes,
see
sir.
all,
That's all I need to know.
I know, for example, that you cite federal rules of civil procedure. I know,
Right.
for example, that you cite 28 USC 2403. I
Mhm.
further note, you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah,
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you